Okay, we got two more cards with this short part of the lesson during the Unit 3 having to do with civil liberties and civil rights. And we need to deal with the Eighth Amendment here, cruel and unusual punishment, 3.15, cruel and unusual punishment, and how this relates to the death penalty, because there's been some pretty big time Supreme Court cases about the death penalty. We're going to kind of briefly go through them here. Now, you don't have to know these in the sense that like you're going to have to write about them, like you'd have to know Tinker versus Des Moines, for example, or Citizens United case. But you do need to know these cases because of the background they give to this issue of how the court has ruled about cruel and unusual punishment. All right, so again, cruel and unusual punishment, that clause is in the Eighth Amendment. There was a famous case, Furman versus Georgia, 1972. Again, Furman versus Georgia, 1972. And in it, Furman versus Georgia bans the death penalty as cruel and unusual. And the reason they said that the death penalty is cruel and unusual is because it was arbitrary in application. Arbitrary means kind of random. So like in some states, like especially in the deep South, there were cases where it looked like if you were a African-American man and you were convicted of murder, then you get the death penalty. But if you were a white guy, you probably didn't. So it looked really arbitrary about who was given the death penalty, and that's why they banned it. Now, under the Constitution, it's hard to argue that that the death penalty itself is unconstitutional simply because there's several places where it says you can't have your life, liberty, or property taken without due process. Well, the fact that it says you can't have your life taken from you means that in certain circumstances, the founders and the writers of the 14th Amendment believe that your life could be taken. So you can't really say that the death penalty is unconstitutional in that sense, but it could be applied in a way that's not fair. And that's really what the Supreme Court was ruling here, that states needed to go back and make sure that the way they applied the death penalty was fair. That led to a second case 4 years later, Gregg versus Georgia. So we have two different Georgia cases. And in it, the Supreme Court ruled the death penalty could serve social purposes of retribution and deterrence if applied fairly. Could serve purposes of retribution, meaning like, hey, you murdered a bunch of people and like, here's the deal, you deserve to die. That's kind of the idea of retribution. And then deterrence, and there's a lot of debate over whether the death penalty really deters someone from killing if applied fairly. All right, so those are the two big cases here when it comes to that. All right, we're done with that one. If you need to keep going, if you're still in writing, go ahead and pause. All right, second thing, and then we're done with this short video, 316, unreasonable search and seizure. So obviously here we're dealing with the Fourth Amendment. So unreasonable search and seizure. All right, cool. Here we go. All right, Fourth Amendment. The government after September 11th has started to collect metadata. Now, this is going to be longer than the definition that I have here right now, but just the first part. Metadata, think meta is in like lots, huge amount, okay? And then data means like stuff from your phone. This is information about a communication. Typically, we're talking about phone, but it could be an email as well, any sort of communication. Phone, email, and text. And that does not include its contents. So let me be clear. Metadata would say who you called and how long you spoke to them, but doesn't include the audio of it, right? It wasn't recorded. Email, who you sent it to, when it was sent, how much you emailed them, but doesn't include the actual content of the email. Although certainly the government could probably get a hold of that fairly easily. But the question is whether if they get a hold of it, do they need a warrant? That's the question. Like, is your email same as the papers inside your house? Are your texts on your phone going to be treated the same way as, your documents inside your house? Do the government need a warrant for that? After September 11th, the National Security Agency, or the NSA, collected data, metadata, I should say, under the USA Patriot Act. So under the Patriot Act, the National Security Agency started collecting data. So any phones, emails, texts that anyone in the United States made, and they could basically search it. Eventually, though, there was an outrage over this because it came out that they were doing this, and everyone's like, what? They have a list of all my phone calls and all my emails and all my texts over all these years. And people were very angry. So Congress passed a law called the USA Freedom Act, and that kind of overturned it. That overturned and took away NSA's ability to do this. And now they have to kind of get permission from a court in order to do it, kind of basically warrant. And then also, there was a case in 2018 called Carpenter versus U.S., where a citizen sued the United States government saying that this is a violation on unreasonable search and seizure, and they won. And in this case, Carpenter won, and it said that your cell phone data is protected by the Fourth Amendment's unreasonable search and seizure. So if the government wants to read your texts or your emails on your phone or have data on who you called, they have to get a search warrant just like they would if they needed to search your house. So that is the end of this card. So basically, you've got metadata, you got NSA collecting data, and then it gets limited by the USA Freedom Act. And then the Supreme Court smacks down the National Security Agency and says, you can't collect all that. That's protected by Fourth Amendment. You got to get a warrant. All right, awesome. Done with that. You got to do your practice or study these cards, then do your practice. Thank you.